One of the False Claims Act litigation questions we sometimes receive here at the firm is, what is a partial lift of the seal? To explain that, let's first delve into what it means for a docket to be sealed. Under the False Claims Act, it's a unique statute in which, when you invoke it, you file the case confidentially with the court under seal, and by under seal it means it's not part of the public record. Generally, when you sue an entity, it's part of the public record, and for the litigation to proceed, it needs to be served on the defendant. Plaintiff initiates the action, litigation proceeds by serving the defendant, and defendant either answers, defaults, or moves to dismiss. In False Claims Act litigation, the case takes an entirely different trajectory. Since it's under seal, that is confidential, not part of the public docket, the defendant is not served a copy of the complaint. In fact, the defendant may not know about the complaint for quite some time, possibly forever. In the past, certain jurisdictions at the conclusion of the case kept the case sealed perpetually, meaning it was never opened up and made available to the public. In recent times, though, courts have pretty much eschewed or disliked that practice. And at the conclusion of the litigation, there is a public record of the litigation, even if the defendant's not served with it. And that can happen in a variety of ways. But going back to the question that brought us here today, which is, what is a partial lift of the seal? So the sealing order by the court generally says that the information in the complaint is restricted to those who pretty much have a need-to-know basis, and those are articulated as generally the Department of Justice, the federal government, the state governments, who are the true parties of interest in the False Claims Act, and the relator, which is also known as the whistleblower, and the court and its staff. And nobody else is supposed to know about that according to how it's sealed, how it's held inside. But at some point, the government, in its infinite wisdom, as it continues to investigate the litigation, may decide it's time or appropriate to share allegations in the complaint or the complaint itself with certain entities. Generally, that entity is with the defendant itself, although there could be some permutations and situations in which they might want to share it with a third party. But the classical route is the government would say, for argument's sake, we think this case may be an appropriate time to hear the defendant's position on it, so we'd like permission from the relator, the whistleblower and the whistleblower's counsel, to lift the seal in a partial manner. When you do it in a partial manner, there is generally redactions. Redactions are when you mark out parts of the complaint, so whomever you're sharing the complaint with doesn't read it in its entirety, particularly if it's going to compromise part of the investigation. The seal, the partial seal lift may still keep the identity of the relator/whistleblower anonymous for that time being, although anonymity is not guaranteed in False Claims Act litigation, which could be the subject of another discussion. So the partial lift would happen when the government suggests it, either the relator/whistleblower and their counsel consent. Even if they don't consent, typically the judge is going to give the government deference because they are the true party of interest in the litigation. And then whatever permutation the court orders, that permutation would be shared with whatever entity the court then orders. So the case would still not be on the public docket, but other people from the seal would then be expanded. Other people would be privy to certain information, either the complaint itself in its entirety, most likely not, the complaint itself in partial, most likely, and that would be the progression of things. It is typically done, as I intimated earlier, in the settlement paradigm, where government is trying to understand the defendant's position about settlement, but also may be done to understand what the defendant's position about liability is. A defendant in the False Claims Act, independent of the lifting of the seal, if there's experienced defense counsel that's used to interfacing with the federal government, at some point we'll start to have an inkling that maybe there is a False Claims Act case behind the curtain. Simple things. If the government keeps subpoenaing information, issuing CIDs, criminal investigative demands, and it seems to focus based upon the language about something, defense counsel who practice this area of law will start to suspect potentially that there is some investigation going on. They won't know whether it's a False Claims Act or something beyond that, some other criminal or civil or regulatory investigation, but they certainly will have their suspicions about what it is. So that's the answer about what a partial lift of the seal is. Hopefully that was abundantly clear to individuals. If it wasn't, feel free to leave a comment, share a question. We love to answer about whistleblower litigation. We're one of the prominent whistleblower firms in the country. It's an honor to serve in this capacity. It's an honor to represent some of the courageous individuals we do who come forth and blow the whistle either overtly or discreetly, depending upon the various programs. For example, SEC whistleblower, CFTC, IRS, you potentially can do it anonymously from start to finish with the use of whistleblower counsel. But even in the False Claims Act context, we love answering academic questions. So if you have it, put it in the body of the email. If it's a case-specific question, if it's a question about your particular case and it pertains to an actual real-life scenario, don't leave it publicly. You can shoot us an email at our law firm or give us a call. We offer free consultations. Not just our firm, there's other quality Ketam whistleblower law firms. Don't leave it publicly because it can only compromise your case. I thank whomever asked that question. We look forward to the next.